All right, we're going to do a real quick recap here in case anybody hadn't been able to make the first session of Hacker Court 2009. This is a case where we had two defendants being charged with obtaining information from a protected computer in an unauthorized manner. The charges stem from the use of a USB key, and the arguments were being developed through direct examination and cross-examination that this USB key can't constitute a computer for the purposes of charging for unauthorized access. The facts here were, as at least as brought out by the prosecution's case, that the defendants had gotten a USB key from a business center at a hotel for legitimate purposes, but they had found on the USB key a file left behind by a prominent financial figure in the economy, and that file had in it a list of contacts that this bigwig in the financial markets had as followers of a social networking site called WANKER. The argument that the prosecution has been developing is that access to that file was unauthorized because there was a posting in the business center saying that users should not look at data on the USB key that's the business center's property if it's not their data. The second charge that's being brought stemmed from the alleged further conduct of these defendants of creating a WANKER account that, according to the prosecution's theory, appeared to be that of this prominent financial bigwig, and had started posting fake WANX to this very influential group of followers of this financial legend. And that had apparently led to some financial problems in our economy. And there the theory being that the defendants had unauthorized access to the WANKER site because in the course of creating this account, they had entered false registration information. So this is a little bit of a quick summary. I've glazed over a lot of the arguments, and all we've heard so far is the prosecution's case. We have not heard anything from the defendant. So we're going to gavel ourselves back into session here and continue with the case. We're back in session. Mr. Ohm, do you have any further witnesses?
Not at this time, Your Honor.
Mr. Bankston, Mr. Opsahl, do you have anything for the court?
Yes, Your Honor. We would like to move to dismiss this case and for acquittal pursuant to the Federal Rule of Criminal Procedure 29.
All right, I have read your briefs, and I understand that the motion you're making here to the court is that I dismiss both the charges and that I acquit the defendants of any wrongdoing here alleged here today. If you would, Mr. Opsahl, let's take up the first issue of the USB drive, and please, if you would, summarize the argument that you've laid out so nicely in your brief.
Well, thank you, Your Honor. The USB drive is not a computer as defined by the Computer Fraud and Abuse Act. As the initial matter, the prosecution has failed to provide sufficient evidence to maintain a conviction, and the government has failed to prove that a USB flash drive is a protected computer. The definition of protected computer means an electronic, magnetic, optical, electrochemical, or other high-speed data processing device. Simply put, this is not a high-speed data processing device. The testimony given by Agent Stroker shows that the device does not process data, it transfers data. It just moves data from the input, from the computer, onto the flash drive without doing any processing. There is no CPU, and his description shows that it is not a processing device in any way.
Mr. Ohm, do you have any commentary on that?
I do, Your Honor, and as I said in my brief, the text of the statute is expansive, and it's been interpreted by several courts as being expansive. Moreover, Congress has expanded this on occasion. The core of it was written back in 1984, when computers were pretty primitive compared to today, and in fact, the USB key in question here, when plugged into the bus on the computer, operated much more quickly than the state-of-the-art computers in 1984. It has storage. It uses magnetic processes. And I think most importantly, what we'd argue, Your Honor, is whether or not this qualifies as a data processing device is sufficiently put into evidence by the expert's testimony and is now just a jury question about a fact and not a legal question that can dispose of the case at this time.
Can you describe to the court what kind of data processing you're alleging or that your witness has testified goes on in a USB key?
Yeah, and so as the witness explained, among the many pieces and components that are on the board and on the chip that form this is something called the microcontroller. And there is logic that is conducted by that basically tells the computer which bits to write where and in what order and where bits have previously been written that might be able to be deleted, things like that. It does a lot more than something that's a passive function. It literally processes the data before putting it into the other part of the drive, which is the flash drive, and we'd contend that that's all the statute requires.
Thank you. And Mr. Opsahl, do you have any rebuttal to that contention?
Well, as was shown in our cross-examination, as the witness testified, that on its own, this device could not function as a computer. If you attached it to a keyboard and a monitor, it could not do any data processing services. And as the witness testified, it transfers information. It does not transform the information. It does not perform any functions like spell checking. There's no processing that is involved.
All right, I appreciate the thoughtful argument here. I think this is probably a question for the jury to decide. So I will not be ruling as a matter of law whether a USB key can constitute a computer under this definition, but we'll be instructing the jury to answer that question based on the definition of the statute. Let's move on to your second argument on the do you have further arguments on the USB count?
Well, my next argument applies to both the USB count and the terms of service on WANKER. And it is that even if these are computers, the government does not have a case as a matter of law on either count because contractual violations do not violate the Computer Fraud and Abuse Act. This court should reject the government's effort to stretch computer crime law in order to punish Jay and Silent Nomad for the tragic failure of the financial markets. Because by doing so, this court would convert the activities of millions of internet-using Americans who disregard things like signs on a wall, which they never saw, or terms of service associated with online service, and transform these innocent Americans into federal criminals. Turning first to the sign, there is no indication in the evidence that there was any agreement, that they made any sign of agreement to it. There's in fact no indication that my clients were even aware of the existence of this sign. The evidence does not show that they signed anything, that it was communicated to them that this was a condition on the authorization to use the USB. In fact, the testimony shows that they were authorized to use the USB device. It was handed to them upon request, then they went ahead and used it. This is authorized access. With respect to the WANKER terms of service, again, there are some serious questions as to whether they had sufficient notice of the terms of service, whether they, in fact, there's no evidence that they ever clicked through to see the terms of service. And in the government's view, account holders who use their WANKER accounts in violation of these terms of service are accessing the computer service without authorizations, and this would criminalize the activities of millions of Americans. The plain language of the statute and the legislative history shows the statute is not meant to punish terms of service violations, but rather it is focused on trespassers and hackers, not users who ignore or violate a site's contracts. The plain language of the statute prohibits trespass targeting the unauthorized procurement or alteration of information, not its misuse or misappropriation, Shamrock versus Gast. And the legislative history also supports this interpretation. When the CFAA was passed, Congress emphasized that Section 1030 deals with an unauthorized access concept of computer fraud rather than the mere use of a computer. Thus, the conduct prohibited is analogous to that of breaking and entering rather than using a computer in committing the offense. Consequently, Congress's committee report emphasized concerns about hackers who trespass into computers and the inability of password codes to protect against this threat. Adopting the erroneous view espoused by the government in this case would criminalize not just Jay and Silent Bob, but all sorts of users who ignore or disregard legal notice hyperlinks at the bottom of a page. Many, perhaps even most, users do not read or understand these documents. They're often riddled with legalese, and they're poorly organized. They're all written at a level of difficulty that exceeds the ability of many users, especially our clients, to understand. And here the government has not shown that the defendants received adequate notice of these terms, or that they effectively consented. Whatever the merits of recognizing these private civil contracts and remedies in civil situations, the imposition of serious criminal liability in light of these problems would be fundamentally unfair and violate due process. Now, recent cases have held that if a user is authorized to access a computer and the information stored there, then doing so is not criminal, even if that access is in violation of a contractual agreement or a non-negotiated terms of use. For example, in a very well-reasoned case, International Association of Machinists and Aerospace Workers versus Werner Masuda, the plaintiff argued that the defendant, a union officer, exceeded her authorization to use the union computer when she accessed a membership list and sent it to a rival union. And it was not for legitimate union business. The defendant in that case had signed an agreement promising that she would not access union computers contrary to the policies and the procedures of the union constitution. The district court appropriately rejected that argument. Here too, the gravamen of the government's complaint is not that defendants improperly obtained information to which they were not entitled on the WANKER servers, but rather that they used the WANKER servers for an unauthorized or illegitimate purpose. But the CFAA does not criminalize unauthorized or illegitimate purposes. Thus, to the extent that Jay or Silent Nomad may have breached the terms of service by using a WANKER account contrary to those terms, it still does not follow they were not authorized to access the servers in violation of the CFAA. The rule of lenity should guide the construction of the statute because it is a criminal statute. The rule of lenity requires a court confronted with two rational readings of a criminal statute, one harsher than the other, to choose the harsher only when Congress has spoken in clear and definite language. But there is no clear or definite language within this that suggests, let alone commands, that terms of service be enforced through criminal activities. Moreover, one of the terms at issue here is the term requiring the real name. And this conflicts with the constitutional right to speak anonymously. And if the court were to interpret the statute to criminalize someone failing to give their real name, you would have a severe First Amendment problem. So the rule of constitutional avoidance requires this court to interpret the statute in a way that avoids the constitutional problems that would arise from interpreting a statute to prohibit anonymous speech.
May I ask you a question in this regard, Mr. Opsahl? In the registration flow, the testimony so far has been that the defendants provided not just an anonymous name, but actually seemed to assume the identity of another person. Does the rule around, does your First Amendment concern differ or change when the speaker is not simply speaking through an anonymous or pseudonymous manner, but has actually appropriated the identity of a known living person?
Well, there are two aspects of this. There is the first and foremost the situation in which they are required to give their real name. And this strikes at the heart of the First Amendment's protection for the right to remain anonymously. Second, there is the terms of services prohibition against impersonating another person. However, this is a part of their speech. In order to criticize, make fun of, show Greenspan to be a ludicrous man, they needed to adopt his identity. Yet they did so with the additional caveat. They said fake Jorge as the username, in addition to providing his full name as the real name. This was part and parcel of their speech, of their social commentary, of their criticism, trying to ridicule a captain of industry, something which is a protected right under the First Amendment.
Thank you.
Well, so Let me just give some examples of showing why it is very troubling to interpret this statute to encompass the vagaries of privately created, frequently unread, generally lengthy, and impenetrable terms of service, and this interpretation would strip the statute of the notice that is required under the Due Process Clause, that it does not give fair notice to people like Jay and Silent Bob and the rest of the internet using community of Silent Nomad, my apologies. And this would render the statute hopelessly and unconstitutionally vague. For example, in this case, we have, in addition to the terms that the government is trying to enforce, there are many other terms that are associated with the WANKER contract that would be impossible for someone to really understand what they were doing or when it would be unlawful. For example, the contract prohibits someone from boring another user. It would be very hard for someone to tell when they're writing a wank whether that in fact would be boring or whether it would be interesting. And to have criminal liability turn on whether or not their wank was boring seems a bit unfair. Does not give fair notice of what is criminal. In addition, the terms require that one not taunt Happy Fun Ball. Many people might want to taunt Happy Fun Ball, not think that that was a problem, not even be really sure whether what they were doing was a taunt to Happy Fun Ball. This does not provide fair notice. And it would also criminalize behavior that many people engage in without thinking that it was really wrong. It purports to say that one may not rickroll the support staff. But everybody wants to rickroll support staff once in a while. This problem is not limited to WANKER's terms of service, and if you adopt the rule of law espoused by the government, this would affect all terms of services. And for example, Google's terms of service say you may not use the services and may not accept the terms if you're not of legal age to form a binding contract with Google. This would mean that everybody under the age of 18 who goes onto Google, types in a search term, gets a search result, has now violated federal criminal law. In another example, the terms of service for the popular site Match.com require that the users are either single or separated from their spouses. For a long time in this country and in society at large and around the world, there were laws against adultery. And as society progressed, we got rid of those laws and we made it no longer a criminal act to engage in adultery. The interpretation suggested by the government would recriminalize adultery. If Congress intended to do that, you'd think they would have been a little bit more clear. So the fallacy of any notion that internet users are on fair notice that disregarding the terms of service to many websites puts them at risk of serious criminal liability is revealed by the widespread understanding that large numbers of users never read the terms or read and understand only limited portions of them. In this case, we have testimony that only 1 in 10,000 users of WANKER reads the terms. On average, they read it for 1.3 seconds, which is clearly not enough time to even read a portion of it clearly, maybe one line out of the 2 pages of bullet-pointed terms that are offered in, if you click through. In other examples, there was a software company that inserted into its license agreement and offered to pay $1,000 to the first person to send an email to a particular address. It took 4 months and more than 3,000 installations of this software before anybody noticed and claimed the $1,000. Many terms of service contain clauses which state that the website owner can unilaterally change the terms at any time, including the WANKER terms. In fact, it says that they can do it for any reason, including but not limited to general mood swing. Under the government's expansive view of the Computer Fraud and Abuse Act, a person's access to WANKER would be criminal if that person used WANKER, even if they were one of the 1 in 10,000 who read the terms, understood the terms, and obeyed the terms, and then a new term was added to it. They went back there and they didn't go back to the terms of service and read it every time they got onto the service before they sent 138 characters to their friends. And however challenging this view may be for civil contract law, raising the question of whether this was indeed an enforceable contract in a civil context, to add this to criminal activities makes it void for vagueness. This case is reminiscent of the United States versus La Macchia. This was a case which dealt with a similar situation. In that case, La Macchia had engaged in non-commercial copyright infringement. At that time, the copyright statute did not have a criminal provision that encompassed non-commercial copyright infringement. Now, eventually, Congress went and added that provision into the Copyright Act, but they still wanted to go after La Macchia. And so instead, they went through the wire fraud statute and tried to say that that statute covered unauthorized non-commercial distribution of copyrighted software over the internet. The court appropriately rejected that argument, as this court should have rejected the argument here. The court asked whether new wine can be poured into an old bottle and said no. And it refused to criminalize the conduct not only of persons like La Macchia, but also the myriad home computer users who succumb to the temptation to copy even a single software program for private use. So therefore, the government's overbroad construction of the Computer Fraud and Abuse Act in the indictment cannot be squared with the plain language of the statute, its legislative history, the constitutional requirements that criminal statutes provide citizens with fair notice of what behavior is criminal and what behavior is not, and it cannot avoid the vagueness, it cannot avoid the possibility of arbitrary and discriminatory practices on the part of the prosecutor. It creates a situation in which everybody's a criminal, and it's only those who the government decides should be prosecuted in whatever arbitrary and discriminatory manner they choose will face the weight of the law, while others violate the same statute and get away scot-free. This is too much power to be put into the hands of the government. And finally, with respect to the requirement that our clients give their real names and identify themselves as who they are, this statute cannot be interpreted to require that. Otherwise, it would have a severe problem under the First Amendment, and the doctrine of constitutional avoidance requires this court to interpret the statute to avoid that problem. Therefore, defendants urge the court to enter a judgment of acquittal.
Thank you, Mr. Opsahl. One question here, a couple related questions, with regard to whether civil agreements between private parties could ever become a criminal matter. It strikes me that the difference between being a gracious host to a visitor in my house and being a kidnapper is one of my having consent of the visitor in my house to being there. If I lock them in the house without their consent, I'm a criminal kidnapper. If they're there with my consent, I'm merely a host of a lodger. And by the same token, the guest who is unwanted and I have not provided consent is a trespasser, where if I am willing to have them in my house, I've got a house guest. And the criminality of my conduct and the criminality of the visitor all turns on the private relationship that I have with that person. So is there something different here?
Well, there is something different here. In the case of kidnapping or false imprisonment, if you lock the doors and don't remove somebody, it is clear where the consent is and where the consent isn't. In this case, there is no evidence that they had notice of these terms, and these terms are hidden, confusing, and somewhat arbitrary, where 1 in 10,000 people don't even read them. In the case where you are kidnapping somebody, it's going to be pretty clear right away that is something that they don't consent to, because they might, for example, go towards the door. But if you lock the door, not intending to kidnap them, then they could come to the door, ask to open it, and if you said no, then perhaps it would be a kidnapping. If you said yes, then they could go. But in either case, their consent to staying there, their consent to your behavior is clear, and they have they can understand where the law says and where the line is being drawn. That if you are holding someone without their permission, then this is a criminal activity. When you're holding somebody, or when somebody is your guest, this is not criminal activity.
Right. Thank you. Mr. Ohm, do you have a reply?
Yeah, I'll keep it brief. The briefing has been extensive, and so I just want to respond to a few of the arguments. As I see it, the defense raises 4 arguments. I think 3 are completely premature at this phase and shouldn't even be considered, and the 4th, I will argue, should be decided in favor of the government. The 4 arguments are basically a series of factual questions that are the province of the jury, questions about plain language that, let me amend what I just said, that you can rule on, but the great weight of authority is on the side of the government, policy questions that are better directed toward Congress and not toward this court, and then some constitutional arguments. So let me do these very rapidly. The defendant raises several times, and including in response to your last question, what are essentially jury questions about: did they see the contract? How large was the type? Why didn't the log reflect or not reflect what happened in this case? These are jury questions, and the government allows that these should be submitted to the jury, and the jury may rule in adverse to the government, may rule for the government, but these aren't questions of law that are appropriate at the Rule 29 stage. And then the defendant, in a related move, takes what are essentially lots of hypothetical examples from the rest of the world and tries to bring it into an as applied constitutional challenge in this case. And we would argue that you should focus on 3 terms of service, and those are the impersonation, the real name, and they do not use while intoxicated terms of service. And we would submit they don't submit themselves to the sort of vagueness or overbreath that they're talking about here. They're not vague at all. You know if you're impersonating someone, you know if you're using your real name. I suppose there's a little vagueness about whether you're actually intoxicated or not, but we have other situations that deal with that. Secondly, they raise a plain language argument where they point to statutory legislative intent from 1986 and to a couple district court cases. The great weight of every court that has ever considered this has said absolutely a Computer Fraud and Abuse Act violation can be premised on a violation of terms of service. This extends from Judge Posner in the 7th Circuit in International Airlines v. Citrin, in which a faithless employee who was ordinarily allowed to access files and delete those files stepped over the line once he decided to help a competitor out by deleting it. They extend to EF Cultural v. Explorica, where a vice president violated his employment contract that had a non-disclosure agreement to help a competitor scrape the website more effectively. And I could go on and on and on. I think if you look at the cases we cite versus the cases you cite, you will see where the great weight and direction of the authority is. Third, Congress has expressed through this statute many, many, many times, culminating in the statute that we are litigating about today, their intent to deal with real, significant, serious problems that happen online because of abuses of authorization and because of people crossing the line of authorization. And they've done this many times despite the fact that lots of academic critics have said that this goes too far. And so basically, I think many of the defense's arguments amount to policy arguments that should be had in the halls of Congress but not in this courtroom. If you look at what Congress has done, they have extended criminal liability. We won't deny that. The defendant keeps saying millions of people. I'm not sure where that number comes from. We don't deny that there are many people. We also want to remind the court and the defense that the act of prosecutorial discretion plays a very important role here, and that this allows us to do things like go after botnets, and this allows us to go after many other ills that are hard to detect and root out on the internet, because this provides us the ammunition, for example, to gather evidence. Finally, the constitutional doctrine of vagueness states that you read this statute and you do not know whether or not you're violating the law. We contend that there is no vagueness here. The statute requires authorization. Authorization has been interpreted by many courts to not just be technical authorization, but terms of service authorization as well. You can read terms of service and know what they allow and don't allow. If there's an ambiguous case, maybe due process concerns would say those aren't enforceable. There are lots of analogs. Assault and battery are illegal. They are crimes, except when you enter a boxing ring because you have consent. Trespass, whether or not the sign is conspicuous, is often critical in deciding a case of trespass. Under federal trade secret law, whether or not something is a trade secret or a violation depends on the contracts that swirl around this entire thing. This isn't exceptional. Congress has written other statutes like the Digital Millennium Copyright Act where they talk about technological constraints on access. They could have done this here. And the canon of construction says you can look at what Congress has done in other situations to divine the intent of what they do in this situation. So, as I said, there's a lot more in the briefs, Your Honor, but that's the essential crux of our argument.
All right, thank you, Mr. Holmes. Mr. Opsahl, taking account of the time here, do you have much to respond to, Mr. Holmes?
Just a few points. I think a lot of these issues are covered well in the brief. We think that the cases we cited in our brief are better reasons than the cases that the government has cited, with all due respect to Judge Posner. With regards to the policy argument, the statute does not make clear that a violation of terms of service would be a criminal activity. If you want to have a statute that criminalizes violations of terms of service, then that is a policy debate you should have with Congress and get them to change the statute so it says what you want it to say, instead of coming to this court and having a new interpretation that does something that Congress never anticipated. You asked why I think that millions of people, like my opposing counsel has asked, why millions of people are involved. In fact, I stand corrected. The testimony was that billions of people use the WANKER service. And as for the canons of statutory construction, as you point out, that there are more detailed information in the Digital Millennium Copyright Act, and under the canons of statutory construction, you can look at one statute and see that Congress did something there. Their failure to do so in a different statute actually does speak to something, that Congress knew how to do it in the Digital Millennium Copyright Act and did not do that in the Computer Fraud and Abuse Act. And from that you can read that they did not intend to do the same thing.
That's my argument, actually, but that's okay. That final point was exactly my argument.
I understand.
Okay, that they had technical. Okay.
Well, all right, thank you, gentlemen. I've heard the arguments here, and I think that probably the best way for me to go forward on this is to actually withhold ruling until after we've had the close of defense counsel's case and the presentation to the jury for consideration. I think quite a few of the questions that were presented actually are for the jury to decide whether the terms of service can constitute the form of authorization that's needed under the statute. I'm going to presume those as factual questions for now. I will take the motion up after the jury, if necessary, has rendered a verdict. So now we've reached the close of the prosecution's case, and through osmosis and telepathy, I understand that the prosecution would like their exhibits admitted into evidence, and I understand from telepathy there's no objection, so all those exhibits are into evidence. And we have disposed of the Rule 29 motion for the time being. Defense counsel, do you have anything further?
No, Your Honor, I don't think we do. Excuse me, Your Honor. No real lawyer would ever let you get on the stand. They have not made their case. You will do nothing but hurt yourself. Stay off the stand.
I want to tell her story.
Are you okay with this? Your Honor, we do indeed have one more, actually, two witnesses. I realize it's rather unorthodox, but my clients would prefer to testify together. Would that be all right?
The court has no objection.
It's highly unusual, but it may be good for a joke or two, so we're not going to object.
Thank you, Your Honor. It's a bad idea, client.
Will you please raise both of you, your left hand, your other left hand. All right. Do you solemnly swear to tell the truth as you sit here in court today? The quiet one, you can just nod, and the guy who smells like a fish concert, you can say yes.
Do I have to?
You do.
Yes.
Have a seat.
So, could you, sorry. Could you please state your name for the record?
I'm Jay. Oh, this is my hetero life mate, Silent Nomad.
All right. And your occupation, please.
We're kind of in between jobs right now.
Okay. What was your last job?
We haven't had any.
Do you recall where you were on 4/20/08?
420. We were at the marijuana legalization con at Little Caesars Palace.
Well, so you've heard a lot of testimony about what happened that day. I want to just focus on a few things. Did you see the sign that the hotel employee testified about, the one that asked you to please not access the files you find on the USB drive?
The only sign we saw was the one we ordered the pizzas off of.
Okay. So what did you borrow the Little Caesars Palace USB drive for?
We kind of forgot our presentation for the conference. We had to on marijuana economics, so we had to print out an extra copy, and we needed to use their drive to download it.
And so why did you use their Ethernet jack?
NOMAD wanted to check out some new comic books that were coming out. He's just crazy for the comic books.
All right. So how'd your presentation go?
I don't think we made it.
Wasn't that the whole purpose of your visit?
Well, we were too busy wanking, so we kind of skipped it.
Okay. So the USB drive. Oh goodness! Please don't do. Okay. So why did you copy these files off of the USB drive?
Well, the file was named Secret Stash. We thought it was like a brownie recipe or some hot porn or something.
Okay. Did you have any difficulty copying the files? Was there a password required, or was it encrypted or anything?
No, it was 2 seconds. Just drag, drop, owned it.
All right. Did you know who Mr. Greenspan was before you accessed those files?
No, we didn't know who he was. There's so many power players on this guy's list, though. It's like we knew that this would be a hell of a lot of fun.
So, okay. Well, let's. Your Honor.
I have no idea who you are.
Okay. Well, let's talk about Wanker. Which one of you actually created the fake Jorge account?
I don't remember, man. We're kind of bombed on these brownies, and could have been Bob, or could have been Nomad, could have been me.
Okay. So when you or Nomad was on the account creation page, did you see any reference to any terms of service?
No, man, we just saw this button that said start wanking, and we were going at it.
All right. So you didn't click through a link to any terms of service?
Why would we do that? I mean, it's not like they're important or anything.
Oh, yes or no?
No.
Okay. And so you didn't read any terms of service?
No, man, we just started wanking.
Okay. So did you think you were doing anything wrong when you provided this fake name and created this fake Jorge account?
No, it's the internet. I mean, who the hell uses the real name on the internet? There's all sorts of weirdos out there.
So what did you intend to accomplish with this fake Jorge account?
I don't know, just high and fooling around. We wanted to see what, it would be funny if, Kevin Bacon and Hillary Clinton were reading some of the BS we were putting out there.
Did you intend to profit from the fake Jorge account in any way?
No, man. Why would we do that?
Did you, I don't know, buy any or sell any stock on 420 or in the days following?
Hello. Yes, we actually, no, we didn't, because we prefer mutual funds.
Okay. So you've heard testimony about how your use of the fake Jorge account hurt the economy. How has the economic downturn affected you?
It really sucks, man. My mom's charging me rent in my basement for, sleeping there and my storage of all my comic books.
And
Yeah, and our buy and hold strategy didn't seem to hold up like we expected.
I'm sorry to hear that. Do you have anything else to say, gentlemen? Okay, I have no further questions, Your Honor. Let's get them off the stand.
Mr. Rohn.
So, before we get to the script, so you don't deny that you created this account and sent these winks, you collectively?
Yeah.
Yeah, that's nicely ambiguous. Okay. Have you ever signed a lease before?
Yeah.
And did you read the lease while you were signing it?
Hell no.
And you read every single word? Do you read like half of it?
I'm lucky I can read.
And if so, what would happen hypothetically if you stopped paying your rent?
No hypothetical about it. The guy threw me out.
So let me ask.
False speculation.
He's already answered it.
I ask the answer to be stricken.
I also sustain.
He answered it unspeculatively. So despite the phrasing of the question, it was nicely concrete.
Won't you re-ask it?
I want to get to a tender topic about drug use. This makes me a little uncomfortable. But have you ever used marijuana?
Just a little bit.
Okay. No, in actuality, you get high quite a bit, don't you?
As often as we can.
And when you do you smoke a little bit, a lot, a medium amount?
I don't know if the technical term is appropriate, but a crap ton would be a good description.
And I'm sure whenever you're kind of under the influence, I mean, probably part of the problem is you feel so out of it. It's hard to process things like that must be one of the few downsides.
No, it doesn't. I mean, we can drive high, we can smoke more, get higher, we can fly, gamble, wank.
Okay, yeah, wank. That's a good example. When you were in the hotel and they gave you that USB drive, did you think that the hotel was giving this to you, like they were like imparting the ownership of it to you?
No, we're not stupid. We knew that they wanted it back.
And
so-
what about when you found the file? When you found this file, did you think, this is my file, I'm going to take ownership of this file?
Oh, I made it mine. Finders keepers, man.
Okay, I have one more question because it's been implied that you were not wanking at all about the financial market, but about drugs. But if you can pull up the next exhibit, Buffett costs way too much. What could that mean, but that you were commenting on the Berkshire Hathaway family of investment strategies? What did you mean by that?
No, dude, it's the seafood buffet. It was just too damn expensive.
All right. Thank you, Your Honor. No further questions.
Do you have any redirect?
No, Your Honor.
All right. Do you have any other witnesses?
No, Your Honor.
You two are excused.
Thank God.
Not from the courtroom, but all right, we have now reached the close of the defense case as well as the close of the prosecution's case. So that's the end of the evidence at this point. So what we turn to now are the jury instructions, and you'll be instructed on how to deliberate through the facts as have been presented to you. And then we'll move into the closing arguments, where each side will have a few moments to comment on the case, and then you will begin your deliberations. Let me start off with one of the basic rules for your deliberations, and that is that the burden of proof is with the prosecution here. They have to prove that the defendants are guilty beyond a reasonable doubt, and if they fail to do so, you must acquit them. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the guilt of the defendants. There are only a few things in the world that we know with absolute certainty, and in criminal cases, the law does not require absolute certainty. It doesn't require that the proof overcomes every possible doubt. It's only required that the prosecution prove that there is no reasonable doubt concerning the defendant's guilt on each of the elements. And if the government fails to do so, to meet that standard, you must find the defendant or defendants not guilty. There are different types of evidence. There's evidence that is direct, and there's evidence that's circumstantial. Direct evidence, for example, from somebody who actually witnessed an event and can tell you about it. Circumstantial evidence is proof about a chain of facts which points to the existence or non-existence of some other fact. You also heard today a testimony from Special Agent Ted Stroker, who expressed what is referred to as an expert witness opinion. And in some cases, such as this one, we allow specialized technical expertise to come into the case that's beyond the normal knowledge of the average person, and Ted Stroker was authorized to testify in that manner. That does not mean, however, that you must accept that testimony as the truth. You are only to consider it as you consider all the other evidence in the case. The substantive offenses here are two. First, there's count 1, which relates to the USB key that the defendants, as the evidence has indicated through some of the witnesses, checked out from the business center. To find the defendant and each of them guilty on this first count, the government's got to prove beyond a reasonable doubt that the defendant intentionally accessed a protected computer. In this case, the government's theory is that that's the USB key, that the access was without authorization or exceeded authorized access. Here, the government's theory is that that comes from the posting the sign in the business center, that the defendant thereby obtained information from the protected computer, and again, the government's theory here is that file that was on the USB key, and that the value of the information exceeded $5,000. The second count is very similar, only it relates to the access and creation of the WANKER.com account. For each defendant on this count, the government has to prove beyond reasonable doubt that the defendant intentionally accessed a protected computer. In this case, the government's theory is that that was the WANKER.com machines, that the access was without authorization or exceeded authorized access, and the theory here from the government is that that was the unauthorized access was the result of violating the terms of service in the use of the account, and that 3, the defendant thereby obtained information from the protected computer. There is no requirement on this count that the information be $5,000 of value or more. You've heard and saw earlier the definition of a computer. A computer means an electronic, magnetic, optical, electromagnetical, or other high-speed data processing device performing logical, arithmetic, or other similar device. With that, we will now turn to closing arguments. The government goes first. Mr. Ohm.
Sorry about that. Is this working? Thank you, Your Honor. We're going to be actually a little unrealistic and very, very, very concise with these so we can take some questions. Thank you once again, ladies and gentlemen of the jury. This is a really simple federal statute. In fact, if you could pull that language back up. And in fact, much of the elements that the government is required to prove aren't even contested. The fact that this was intentional and that they accessed these devices, those aren't in doubt. The fact that they obtained information from the device is also not in doubt. It really boils down to two questions. Do you think that the defendants were authorized? And the government contends that we've proved that way beyond a probable, reasonable doubt, because we have demonstrated the terms of service that were offered to every customer, the fact that the account could not be created without acceding to those terms of service as indicated on the bottom, and furthermore that there was a sign posted above the workspace that informed users of the rule of that room, which was do not use the USB key unless and until you agree not to delete files. And then the only other question for you is whether or not this USB device qualifies as a data processing device. And as the government has argued through its expert witness, there is an aspect of this device. It may not look or feel or smell like lots of other computers you use, but when Congress uses words as the judge has instructed, it doesn't mean what you would find in the dictionary necessarily. It means what the jury instructions inform you it means. And in this case, it boils down to the phrase data processing device. And lastly, I'll leave you with an exhortation. The role of the jury is to look at the law, look at the jury instructions, look at the facts, and decide whether they match. Your role isn't to serve as legislature or policymaker, and it really isn't even to decide whether you like these people or not, or you think they're good or not. Congress has expressed its will through the statutes, its rights, and I leave to you the awesome power to enforce that law. Thank you very much.
Mr. Bankston?
Yes, thank you, Your Honor. I have been asked in rather unorthodox fashion to cut my closing very short for questions from the jury. We don't typically do that, but we'll be doing it today. But that's okay. I don't mind having to cut my argument short because the fact is the burden in this case is not ours, it is the government. They must prove beyond a reasonable doubt that my clients violated this statute, and they have failed to do so. So I will simply make one point. Could we please see Exhibit 3, please? You know, I'll be the first to admit my clients are somewhat childish, and well, not too bright, and maybe they indulge a little too much in the, may the record reflect I was making a toking hand motion. But federal computer criminals, I think not. And if they are federal computer criminals, so are all of you other wankers. You may not use the wanker service for any legal, illegal, authorized, or unauthorized purpose. I don't know if that's incompetent legal drafting or if they even got a lawyer at all. But under wanker's own terms of service, no one is authorized to use wanker. And all of the billions of people who do wank are, if my clients are criminals, criminals themselves. I rest my case.
Mr. Rome, do you have any additional arguments?
No, that's fine.
All right, so in a moment, the bailiff is going to escort all of you out to the jury room, which looks remarkably like this room. And they'll deliberate, and you'll have a form, and you'll fill out, and you'll vote. And that is the end of this portion of Hack Recording. So now we move into discussion.
It's not quite done. I don't think I heard an apology.
And you're not going to get one.
Yeah, do we want to, I think I know the answer this year, but we usually ask for a vote, a straw poll, by count, right? You're the judge.
Yeah.
You want to call for the vote?
Yeah, let's, you guys want to do a vote now, or do you want to talk first and then vote?
Okay, let's do
Yeah,
questions first.
let's do questions first.
Yeah.
I have a question on, could you show the Rule 29?
Oops.
It says, from any protected computer. In this case, even though you can say, even if this is a computer, I think this is something else or you need to debate. But to me, this is not a protected computer because I give it to you.
Yeah.
And you cannot authorize that. You don't need to authorize because I don't have any access control. So I don't think this is a protected computer anymore.
Yeah, no, so thank you for raising that. We didn't talk about protected computer. Oh, the question was, why didn't we ever focus on the word protected? Because it seems like the ordinary meaning of that is you take some steps to protect it. That's not what that means at all. Protected, believe it or not, in the statute means the kind of computer Congress meant to protect. And when you read the definition, which I don't have exactly on a slide, is if it affects interstate commerce. And if you're a lawyer, you know that that's magic language that basically means any computer on Earth. There are some arguments that maybe it has to be connected to a network, maybe not. But I think there are very strong arguments that Congress meant anything that fits the rest of that definition. So thank you for raising that point. Yeah.
So we went way over the top on that. Oh, so the question was whether, when you're drafting a terms of service, if it has to be enforceable, and whether what we drafted was enforceable, and we admit we went way over the top for the entertainment value of this, but if you look at just about anybody's terms of service, I guess I'll let the lawyers answer that as to enforceability.
I mean, Kevin pointed out the one that's internally inconsistent and therefore completely unenforceable. And there were other things on there that probably you couldn't sue someone. Like when you say enforceable, I think, could you sue them in court for breaching the contract? I'm sure there are lots on there that probably wouldn't pass that test.
Well, I think there's one that did pass that test, and that would have to be the first one, which was you will never ever pretend to be a teenage boy to cause your daughter's enemy this week to commit suicide, because, that's so bogus.
And I think
Well, actually, I mean, if we could talk about the Lori Drew case,
Yeah,
I think
that's, yeah.
put this in context. Someone other than me.
Well, I mean, so it's no secret, right? The reason we chose this scenario this year was because of the Lori Drew trial. And for those of you who may not know, I'm sure a lot of you do, this is the woman in Missouri who helped her daughter create a fake MySpace account pretending to be a boy in order to mess with another girl, and that girl ultimately committed suicide because of things the boy said, prosecuted in California, and just a few weeks ago, the judge in California threw out the only jury conviction under this exact same statute, by the way, because he ruled that it was constitutionally overbroad. But there's a lot more we could say about that. So that, I mean, this is like ripped from the headlines, real life, that this statute kind of does operate the way that, or at least the government thinks it operates the way that I was portraying in this case.
So would this be a good time to talk about the enhancements to the statute under the the vice presidential
Let's
protection?
take some more questions. There's a lot of hands. Yeah.
Impersonation. Now, in this particular case, the username was fake law.
Yeah.
What would be the standard to impersonate somebody? Does the original person have to believe that that impersonation is true? For instance, you have the real one, the fake Steve Jobs,
Right.
everybody knows that that's not really Steve Jobs.
Right.
Is that case of impersonation? Or?
I don't know if you're a lawyer, but that's a good question. I mean, that's one of the questions that would definitely be fought over if this case were real. One thing I'd say is there were two acts of impersonation here. The government would say there was the impersonation to the rest of the world, and then there was the impersonation to the WANKER administrators, because they said, my name is Jorge Greenspam. In either case, you might say, yeah, but the word fake blows impersonation out of the water. I mean, one thing they did in Lori Drew is they said she violated 7 terms of service, and I only need to prove that she violated 1, right? So we could even lose on one of those and still get the conviction for the other ones, but it's a good point.
Oh, sorry, person way on the end.
With the USB, being that the USB was in a public internet type domain, is a file that the gentleman left on the USB when he failed to erase it. Isn't it that you don't expect privacy when it's left in the public because he doesn't own that file now that it's been transferred to a public internet cafe type? And the gentleman that came on afterwards, if they didn't protect it to erase it, it's now public domain, right? That file. Do you expect privacy of stuff that you need? Like, we don't expect privacy of
Right.
stuff we leave on.
I think there's a fair point that Jorge had abandoned any rights he had to that file by leaving it on that USB key. And having done so, he's sort of screwed if it gets out there. And maybe he could do some tricks like naming it in a certain way. You could certainly put some crypto on it and try to take some technical physics. But yeah, as a kind of a matter of law in the U.S., he's probably abandoned whatever rights he has to it. Now, there's a second stage to this, though. He's put it on the business center's device, and the business center has tried to exert control over data on that device by putting a sign up. So then the question here was, did that sign effectively, as a matter of law, provide legal protection to the business center's rights over this abandoned data? And it's kind of claimed as its own. And that's part of the deliberations you have to undertake.
This gentleman here and then the gentleman in the back. Go ahead.
Is there any prior casework on defining small, specific purpose computing devices as a computer or not? Like this USB thumb drive, it seems like a pretty critical part of this case is this USB thumb drive, while being very simplistic, is still a computer. Or is this the first situation where this is being tested in court?
I've never seen.
No, we've never seen it. I mean, this is something we dreamt up. The Lori Drew facts we wanted to focus on most, but this one sparked our interest because we didn't know the answer to it. So.
Last year, there was a case involving DEFCON and talk about the MBTA
that's right.
system. And in that case, the MBTA said that their RFID fare card was a computer, but that turned out not to be important to the decision of the case. The case ended up turning it on the ground, so they didn't have the court answer that much.
Let me add to that. To add to the USB argument, does the USB drives that have built-in cryptography that actually calculate the data, does that modify any interpretation?
It would make the argument better than a computer. I mean, the thrust of our defense on that was that there was no processing, and a cryptographic USB drive would do additional processing, but it may not be sort of the
type of crime, one could argue still over that, whether that is processing in the sense of whether it's that's yeah. And so as a defense, we would say that that in itself is not enough to pass the process in the sense of a CPU, in the sense of a computer.
I'll just add that it's, I mean, the definition is considered so broad, or Congress thought it was so broad, that it found it necessary to specifically exclude portable calculators.
Okay.
So,
I think there's a question back there.
Question in the back?
The business center gave them that for use, and the sign was basically a request, or could be interpreted as a request rather than
Yeah, I mean, we should have had the sign up there, but we were in the room planning this, and we sometimes had the word should, and then we took out the word should. The word please was still in there. I mean, this is the kind of ambiguity real juries would have to answer in a case like this.
I mean, it turns on what you think please means. I mean, please do not, it could just be a polite mandate, or it could just be a request.
As a writer, I like to comment on that because I do a lot of technical writing and editing, and what irritates me is the ambiguous wording that people have for things, such as you'll see in technical documentation, click on this icon and a window should appear. So the word should drives me crazy because it's either it does or it doesn't. So part of the things I want to point out with this is people are vague in their writing, especially somebody who's not a professional at doing this could throw something out there that they think is a rule, and it's just worded really badly. So.
Question right here?
Yeah, the law, I think, says that you have to obtain information from the computer to access it.
Right.
Hmm?
Well, that was actually something we discussed, is, well, what's the information there that they're getting? Well, the theory is that by authenticating and opening an authenticated session with WANKER, they were then presented with screens that only an authenticated user would see. They might see a special colored background. They might see links that they wouldn't see if they weren't authenticated. It's not valuable information, but it was information that they wouldn't have seen had they not gone through this fraudulent, this is the government's theory, fraudulent registration process. So in this case, it would have been very difficult to say that there was $5,000 worth of information obtained because they got this access, this cookie on their machine saying that they're authorized for this session. But the statute doesn't require it just says you just have to obtain information. It doesn't say it has to be valuable information. And yeah, go ahead.
I mean, Richard and I both worked at the Department of Justice in the unit that looks for computer criminals, and whenever we had an unauthorized access into a Unix machine, our argument was as soon as they typed ls, or probably before that if there was a motd file, we had them, right? Because they obtained information. The rest of it was just all gravy, but that was the misdemeanor right there.
Okay, we're good?
You said that the drive is ultimately the responsibility of the business center, right, after they got it back, or would it be their responsibility to ensure that it would be data at that time and not the responsibility of the person? Why should they be, yes, but still, why should they be responsible for the information that was left on there? Yeah, ultimately, the drive was given back to them and it was given out. So it should be the responsibility. Does the business center sue in any way for this, or is it still, or just the two individuals?
Yeah, I mean, there may be a civil suit going on behind the scenes, right? That could be the case. And I think if we'd had longer time, I think Kevin would have developed through the witness, like, why didn't you just clean this thing off, and how hard would that have been, and weren't you clearly, allowing people to have access? Kind of built that up. That would have been part of the case.
I'd like to just hold questions for a second. I would like the attorneys to spend a few minutes on the enhancements to the CFAA as it pertains to the Vice Presidential Protection Act.
I mean, we'll do this really briefly, but this is really fascinating. How many of you in this room have ever heard someone talk about the Computer Fraud and Abuse Act before? Okay, good. I mean, I think that's self-selection on who comes to hacker court. Probably a lot of what you know about the statute is wrong, because the statute was amended last year very, very quietly in what was known as the former Vice Presidential Protection Act of 2008. That's the title. And what is the former Vice Presidential Protection Act of 2008? It's the law that says once Dick Cheney retires, he gets a Secret Service detail. In the past, only the former presidents and first ladies got the detail. And so if you pull up the statute, we should have had it, but it's 3 sentences about Dick Cheney, and then it's 4 or 5 printed pages making the Computer Fraud and Abuse Act much, much, much broader than it used to be. So some of you may know the $5,000 requirement. It's a different one than the one we did in this case. You need to cause $5,000 worth of damage in order to be a federal crime. No longer. Now, when you cause the first penny of damage to a computer, you've committed a federal misdemeanor. And as I interpret that, that means every single practical joke ever done in an office on another computer is now a federal crime. It is, and the FBI can investigate it and they get search warrants and all of the rest. And the second one that you may know is that for some of the particular crimes, you need a communication to actually cross a state line, and it has actually scuttled a lot of cases. And think about our case. We wouldn't have been able to show that for the USB key. That's now been written out of the law. For that particular crime, you no longer need an interstate communication. And what this really does is it takes a lot of conduct that would have been state only and it federalizes it. And it broadens, and it just amazed me. Like, some of the leading experts in our field didn't realize that this amendment passed until 6 months after the fact. So it's amazing to look at how this law gets amended by Congress.
Brian?
Following up on what you said, Richard, so if a file is left behind and the person no longer has rights to it, is that what you said?
Well, I was saying the facts here you could easily make the case where you've just abandoned it. It's the garbage out on your curb. It's, something you've just left out in the public.
So if a government employee has a database of social security numbers, keeps it on a train, is that now considered an abandoned piece of information? If I find it, do I now have rights to it?
I mean, there can be silos that protect information so that it actually retains some protection in spite of a careless official. So in this case, we didn't have anything like that, really. I mean, maybe there could have been arguments that...
Well, I mean, like copyright's an easy one.
Copyright.
Copyrighted materials are still copyrighted
trade
even if you
secret
leave
stuff,
them on the
maybe.
train.
Right.
Yeah, trade
Yeah.
secrets are different, but yeah.
Gentleman right here?
So the concept was brought up that you were a certified expert on USB drives.
Right.
What is the process for determining that you are an actual expert? And is there something in place that says that the defense can also have an expert at the third level?
These are great questions.
Yeah,
So-
well,
so
and I'll just add, I mean, we of course would have had in a real trial, we would have had our own expert opining that it wasn't a computer.
So I've actually been qualified as an expert in a federal trial. And what happens is I go through the voir dire, which means the attorney that I'm working for would ask me a bunch of technical questions about my expertise. The opposing attorney would try to diminish my capabilities and show that I wasn't an expert. And then at the end of the voir dire, the attorney would ask that I be admitted as an expert witness. Then it's up to the judge to make the decision whether I'm qualified or not.
So really it's just a matter of somebody else in the room not being more qualified.
That's not it. It's not it. There's a minimum bar you have to clear, and it's based on the standard of the science and what papers have been published. As long as you clear that, you're an expert. You don't have to be the most qualified. Yeah.
The reason that I talk about this is because with DNA specifically,
Yeah.
the testing that they've done, there have been a lot of cases where they proved that the expert in the case didn't actually know as well as they should have been.
Yeah.
And they took the case back out, and the FBI reviewed it, and a bunch of other defendants, and then said, wait, this guy was completely wrong. Why was he admitted as
Yeah.
an expert in the case?
I mean, there's several things swirling here. For those of you who know the cases, there's the Daubert line of cases that talk about, like, when we see something that's scientific, how are we as judges and lay people to know who's good enough to sit in that witness stand? And, what you're pointing at is maybe they're wrong, and maybe on appeal someone will point out they're wrong, but that's not the same thing as saying they should never have been qualified as an expert in the first place. Here's a really black hat take on this. What is an expert in the field of computer forensics, right? Who is it? Is it a CISSP? I should hope not. Is it someone who's read particular books? Computer forensic technology is a really hard question, and it's one that courts haven't had to answer. And I have actually been invited to write a chapter in a scientific evidence treatise in the spring. So if any of you have insights about how courts should draw lines around what you guys all know, please let me know, because I think it's going to be a really hard question to answer. Yeah, and in DNA, it's really well defined. This is where it all gets fought out. DNA, you have to have the right letters after your name, you have to have the right kind of lab, et cetera, et cetera, et cetera.
Gentleman in the back over there?
Going back to the statute, so they access the computer, and you were saying that once they have retrieved information, so it
Oh, that's a good point. I mean, again, you guys are lawyers who are issue spotting. The government would say you intended to type in the username, you intended to type in the password, and the system, as part of the system, returns the message of the day. Yeah, so you might win that argument, but then what comes right after that? The prompt. That's information, right? So, and then you typed in a command and another prompt. I mean, I think we're still going to win that one, even if you win the MOTD argument.
I'm going to have to hold questions because we're at time, but we'll do, we want to call for a verdict, and then we'll hang around here. If you want to come up and ask us additional questions, please do. So, Richard?
So count one, the USB key, I don't know if you want to put the instruction
I
up,
don't have
but
the-
the access to the USB key and obtaining data there, how many people here would, we're going to treat these defendants as though they're one person, you know, joined at sides. How many people would convict on count one, USB?
I would.
You got,
We've got a couple.
Can we break that down into protected computer? And was it? Did
okay,
anyone?
you want a special verdict?
Yeah, I want a special
Okay.
verdict. How many here voted no, not a conviction, because you do not think a USB key is a computer?
Okay.
Okay, and then how many of you? It could be some of the same people voted that way because you think they were authorized, or they weren't without authorization, because the sign wasn't good enough. Okay. Did I miss any other theories? What's that? Yeah, about the sign. Yeah. I mean, at one point we had it as a label on the USB thumb drive. Would that have changed the vote of anyone? If it was a label that was printed a lot more conspicuously on
Or was it the language that of the?
both? Yeah, no, that would have been the easiest one, but we're always trying to balance this.
Right.
What about
Okay.
using some kind of U3 auto prompt or something when they put a U3 drive in, a pop-up comes up and says,
Yeah, that was the other option. It popped up as pop-up, yeah.
How many of you wouldn't have convicted at all, regardless of anything?
On the USB? Okay. And then,
The other one was the terms of service
Yeah,
violation.
yeah.
Someone slipped my application because it said I didn't, the prompt came up, the prompts were different, like the banner that pops up is the warning banner. The warning banners were different at different places.
Yep.
Market that. So it's now the notification of a warning agreement, every user has to sign a user agreement saying they have seen it and that they understand.
Right.
So that's the signature.
Yep, so that's one practice. So let's move on to the second count, which is the creation of the wanker.com account and then the WANX that followed that. How many people here, I'm just going to ask for the verdict, and then you can do the special thing. How many people here would find guilty on that charge? Sure, that's the charge that says that the defendants created the wanker.com account and used it in an unauthorized manner. Unauthorized because in creating that account, they put in false information. They may have been intoxicated at the time that they created the account, and is that it?
Violated the terms of
They were, in other words, they violated the terms of
And they
service.
impersonated someone.
And they impersonated somebody, yeah. And so they were charged with the same, basically the same count. Okay. No, in that case, they just had to have obtained information. There's no requirement that that information be valuable or that it hurt somebody that they obtained it.
And so welcome, fake Jorge. Let's start wanking. Page would be enough.
Is this count primarily based on the terms of service or something else on the impersonation of someone like?
It's based solely on the terms of service.
Yeah, not primarily, solely.
Solely on the terms of
So
service.
who finds that a violation of Section 1030? I did.
I did.
By saying exceeded, it says unauthorized or exceeded authorization. What does that mean?
That typically, whenever Congress talks about that, they talk about insiders versus outsiders. That if you have some access, but you find a way to elevate your privileges, that's the exceeding. In this case, I think the government would probably argue both, but I think they would more aggressively say you were unauthorized at that point, right? When you broke the rule, you were no longer an authorized user of that network. The requirement to use the network was you agreed to these rules, and when you break them, you're no longer authorized. You're lawless on the network, basically. And I think that's the Lori Drew theory too.
Yes.
I'm curious, for those who were not going to vote to convict there, did you feel that they violated the terms of service, just on that pure factual question?
We didn't have that in here, but let's assume it was in there.
Yeah,
So let's go on the assumption that it was in there, that it
And
was
assume
very
the terms of service weren't ridiculous.
Yeah, I mean, we did it. We went over the top for comic reasons.
Yeah, yeah.
Well, at any rate, it wasn't, at any rate,
There's no
Jorge-
question that their name isn't
Jorge
Jorge
Greenspan.
Greenspan.
That's the issue here.
You mean like in terms of the First Amendment argument, like that this violates the right to anonymity, or I'm not quite sure.
Yeah, right.
Yep.
Like, if I say you can't wear a pink shirt in my house and you wear a pink shirt, you're in violation of it no matter how ludicrous it is? Is that?
Yeah, if you wear a pink shirt, I'm not letting you in my house, and they come in your house anyway. Then maybe they are trespassing. Hey, here's one thing I'll say that is crazy. Is crazy. We were in the room trying to say, all right, how much doubt should we have about the terms of service? Should we have a checkbox? Should we have the checkbox pre-clicked? Should we have the checkbox not pre-clicked? And we had this elaborate thing. You know the thing we had up there with the tiny print? That's from Twitter. That's a direct lift. No, the next one. That's a direct lift from the Twitter webpage. And so that's how they do it. They don't have a checkbox.
They also have a continue.
What's that? Say that again? Yeah. Yeah, I mean, in the statute, as according to the government's theory, and the government advances this theory in Lori Drew, the statute itself sucks in those two legal questions into the prosecution. Yeah. So maybe we should let people go to the break if they want.
Yeah, anybody who wants to go to lunch, go ahead. Anybody else who wants to stay and ask more questions,
Thank you for
please
your
stay.
attendance.
I'd like to thank you for attending, and we'll take more questions, whoever wants to stay.
Oh wait, what about our special verdict?
I think we're probably done with that.
Okay.
I think you guys got acquitted.
All
What's
right.
his hit?
I'm sorry, go ahead and ask your question.
Go ahead.
Has there been a case before where someone modified the terms of service and then submitted it to the site, or no?
You know what's funny? We talked about that in the back room, and I actually wrote a blog post about this, pointing out that when you use Panera's Wi-Fi, they use the editable terms of service. They use an editable field for it. And so every time I'm there, I delete the whole thing, and I say, you owe me a free muffin every day. And it's funny because I've run it by a lot of contract law professors, and a number of them have said, no, not enforceable, counteroffer. But a few have said, no, you're onto something there. Maybe that does become part of the binding contract.
In the back?
I should. No, that's a great point. I think the real jury instructions would have said, this is what authorized means, and you can't just skip that step. You, the jury, have to decide whether they're authorized. Yeah. Right.
Right. And Twitter does the same thing. Twitter just says continue.
But there are. I mean, before we had the internet, there were cases like that where you entered into the contract not by signing your name on a sheet of paper, but by doing the agreed upon act, right? By starting to work in my backyard, you agree X, Y, and Z, and you don't sign a piece of paper, but the courts have still said no. You've still manifested your intent to enter into a contract. So then it becomes a fight of how explicit do they have to be, how conspicuous do they have to be, can they ever do it without a checkbox? Can it be opt-in versus opt-out with whether or not you check it? All of those things are important, but I don't think it's right at all that you have to throw the language in their face